Hello, hello, hello. It's Johnny Mike Gravel coming to you from Chicago. As usual, I have to thank some of the usuals. What do we have here? April hooked me up. Natalie D has the last second contribution to the stream. I have not seen 1 second of it. She calls it painfully delicious. That's at the end. And Kristen up in Traverse City sent me a clip. It's fantastic. It's a slow. It takes a while. You gotta get the foundation first. In fact, I messaged her. I said after the first few minutes, I'm like, why'd you send me this? Oh, don't worry, it gets worse. It gets much, much worse. Let's do it, shall we?
Good morning, Mr. Thick.
Morning, ma'am. How are you?
I am super. How are you?
Not well at all.
Sad to hear that, Mr. Thick.
Okay, Mr. Backus, we just need you to connect to your audio on your Zoom app, please. There we go. And I need you to unmute, please. Mr. Backus, are you able to hear me?
Yes, sir.
Okay. All right, we're on the record in Nevin versus Backus. This is case number 2213862. The record should reflect that both parties are present by Zoom. We have Ms. Bostic here on behalf of Ms. Nevin, and we're set for a status conference today, as well as Ms. Bostic. You filed a motion regarding several different types of reliefs. You're looking for some damages related to the home in this case, attorney fees, some injunctive relief, and ultimately entry of the judgment of divorce. Is that correct?
That's all correct, sir.
Okay. Is there anything that you wanted to state in terms of argument? I mean, I went through your motion. I see that you've supplied all the documentation and so forth with that motion. Was there any argument you wanted to present today?
Not too far beyond that, other than, of course, to stand on the motion.
I have a theory as to what's causing that expression. I don't know, but I think he might be having some fun in Costa Rica. I'm just saying.
These are the damages we calculated, and there's, I would leave it to the court's discretion to determine how exactly it would like to calculate those damages. We obviously have a very significant loss of equity between the two appraisals, as well as, and part of that loss of equity is the specific damage to the items that Ms. Nevin was able to identify, replace, or have quotes on. We're also, of course, standing on the request for attorney fees, given the work that was necessary following the damage to the home to get that sorted out. That should never have happened. It was in violation of the mediation agreement. And because the mediation was ordered, there are expectations that a party may be entitled to attorney fees if another party acts in a way that's contrary to a court order, and as well as to the extent that this is sanctionable conduct, the damage to the home after he knew it had been awarded to the plaintiff and after there was an agreement that he would leave it intact with certain fixtures present. We are asking for the injunctive period so that we have an opportunity for the judgment of divorce.
If you're keeping score at home, this is Kristen's fault right here. Thank you, Kristen. The next one will be April's fault, and the final one will be Natalie's fault.
To go into effect. Before this court, there has already been, I know this court at our last hearing raised some concerns regarding the defendant's credibility and his good faith in participating in this divorce proceeding and making funds available. He's previously told the court that he is completely destitute and living in Costa Rica with no money and no or very little income, but the court determined and was very satisfied last time we met that he did in fact receive a very significant payment of money in a liquid form, that if he is now destitute, there should be some questions about where that went. So there should be some assets somewhere, and we would ask the court to...
I'm not saying it went to coke and hookers. I'm not saying that because I don't know. I am suggesting it's a possibility.
Further enjoin any movement of those accounts, just so that we have time to execute the judgment because of the amount of damages that we're asking for due to Mr. Backus' conduct before he left the home. And that's all.
All right. Okay. Thank you. Mr. Backus, what's your position on this?
Well, that's first I've really heard of this motion. I never received anything about the motion, so I don't have much to say about it. Really, I mean, she can try to get what she wants to out of me. I mean, that's fine. I just want to proceed and get this divorce.
Yeah, that's what we're doing here. That's what this whole procedure is.
Over with. As far as assets go ahead and search. So it's, unless you want to come to Costa Rica.
I think that's an admission that he's hidden them right there.
All right, Ms. Backus or Ms. Bostic, it looks like you served Mr. Backus with this by his email address that he provided. Is that correct?
That is correct. Pursuant to his statement on the record, I think last December, that he preferred electronic service.
Okay, so Mr. Backus, you might want to check your email. That's how you asked to receive documents.
Yes, sir. I check my email every day, and you know what? She never sent that. She never sent it. So I never received it. She never sent it. I've received every single email from the clerk of the court. She hasn't sent nothing, Your Honor. She could sit there and say she did, but she didn't.
I'll file my outgoing email with the court as well if that's necessary.
Yeah, absolutely. Yes.
Okay. All right. So, Ms. Bostic, first of all, after reviewing the file...
Oh, good Lord, Griggsy. Yeah, you seriously want to talk about law? The court has jurisdiction over the petition before it, whether or not they grant the divorce, and it has jurisdiction over the property of the marital estate. Now, don't ever ask a serious question again. Thank you.
And your motion, I do think that the injunctive relief that you're requesting is appropriate to prevent the dissipation of any further assets while this is pending. I think given that Mr. Backus has located himself outside of the country, given what's gone on at the home when he vacated it, and the condition that it was in, and there's been some exhibits filed to show that condition. I think in terms of the court's equitable powers here, I think in all fairness, that injunctive relief is appropriate and necessary to prevent either side from dissipating any assets until the court can make some rulings and some findings. So if you'll submit an order regarding the injunctive relief under the 7-day rule, the court will sign that. With regard to the damages and attorney fees, certainly that you provided all the documentation for that, but I think the court needs to have an evidentiary hearing and to take some testimony as to how those amounts were obtained and so forth. And Mr. Backus has the right to, a contested hearing to question those amounts as well. So I think if Ms. Bostic, if the court were to set this for, maybe a 2-hour or half a day hearing, would that be enough time for you to present the testimony you need on those exhibits that you submitted with your motion?
Yes.
Okay, so the court will set this for, I'm going to set it for a half a day hearing just in case. at the court's next available date. Mr. Backus, you'll be provided with notice of the date and time of that hearing. To the extent that you want to contest the damages that they're seeking, then you'll need to be prepared to present your side of the case or any evidence that you'd like to bring before the court to contest the amounts that they're requesting, okay?
Yes, sir.
Ms. Bostic, is there anything else that we can address for your side for today's purposes?
Depending on what the court's calendar is, if the half-day hearing would be anticipated to be within 5 days, we could put on the proofs.
I'm sorry, you were breaking up a little bit there. Can you say that again?
Yes. Depending on what the court's calendar is, and if we would have that half-day hearing within 45 days, we are prepared to put on the proofs today. Unless you would prefer that at the evidentiary hearing.
I'm not sure sitting here what my calendar's like, so I'd rather put the proofs on at the time of that hearing. We can certainly do that then.
Very good.
Okay. All right, Mr. Backus, do you have any questions at all?
Yeah, is my divorce final today then? Is that part of it done with? Huh?
No. No.
Pardon? It's not going to be done until we do this next hearing?
No, because I have to make some determinations about if and what damages Ms. Nevin might be entitled to, as well as the request for attorney fees. So all of that would need to be determined before we can enter a final judgment.
Okay. One last question. How long does that usually take from this point on? I'm trying to get on with my life. I got a new baby here. I'm going through the U.S. Embassy for dual citizenship for her, and this is a major roadblock for me. So and this is
Sweet Jesus. What?
on and on and on. It should have been done months ago, but here we are, and now we're going to postpone it again. I don't understand. I really don't, and I feel like at this point, would I be in contempt of court if I do not do any more and just let them do a divorce decree?
This guy's just given up. He's given up. He's doing a lot of stupid stuff, but I mean, he's leveraging U.S. citizenship for a little fun in Costa Rica. It appears he's having fun in other avenues. He's like, how about I just don't show up? How can you just say we're divorced? So she can have anything. You put me in prison. I don't know. Shoot me to the moon. Whatever it is, so I never have to talk to her again.
On me?
So to address your first point, number one, you're the one who chose to move to Costa Rica. That's resulting in a lot of the delays here. Number two, you're the one who chose to leave that house in the condition that you left it in, and that's causing the delays here. And number three, in terms of your question about what would happen, I can't really tell you that. That's up to you. You'll have to decide how you want to go forward. But from my seat, the delays here are all caused by you, so I don't think you really have any cause to complain at this point.
Okay, I strongly disagree with you, respectfully disagree with you. For one, I didn't leave the house in that condition, and that's why the sheriff's department, you said I did. The sheriff's department never prosecuted me. How come there wasn't criminal charges like Miss Bostic said there would be? Remember, she's in her motion, she said that. Okay.
I'm not going to debate with you. We have differing opinions, and that's fine. That's fair, but I'm not going to debate with you. We're going to proceed as I've indicated, and that's how we'll go forward.
Okay. One last question for you. Is there a way for me to appeal your decision?
Again, that would call for me to give you legal advice, and I can't do that. So you'll have to figure that out on your own.
Yeah, of course not, but you will for her. I think she's paying you off or something, but that's all right.
Sweet Jesus. What?
Okay, well, you can pursue that as well if you want. There's ways for you to make those grievances if you want to do that.
Oh, isn't that legal advice?
I'm not giving anybody legal advice.
You just did.
I don't think I did. But
It's time for a contempt order. Yes, you can't enforce it because he's in Costa Rica, but just hold him in contempt and put out a warrant for him. Yeah, you can't let the guy talk to you like that.
It's okay. You won't see me. You won't see me.
I'm not going to debate. I'm not going to debate with you, Mr. Backus. That's all for today.
Yeah,
you can go ahead.
Oh, Sharon, it's all clear to me. I don't know what to say to you.
Yeah,
Thank you.
see y'all in Costa Rica. Pura vida, as we say here.
All right, my Spanish speakers, what does that mean?
Are we adjourned, sir?
All parties are free to disconnect at this time. Thank you.
Thank you.
This is crazy.
You created the problem you had, not me.
I object to this whole hearing. Let's go. I'm done.
But Mr. Walker, please prepare another order on contempt.
Here's my attorney.
Good morning. Are you Sasha Michelle Kenyon?
Yep.
We met. I'm Judge Middleton. Your attorney,
I know.
Mr. Paul Gibson, is not available this morning. So with us is Mr. Keith Stickley, the Chief Public Defender.
Okay.
So
Okay.
he's here from the Public Defender's Office. The file number here is 231118FY. You were
Is it
charged
the
with...
Oh, sorry.
This is the May 31st incident.
Right.
You got arrested on July 11th and then promptly missed multiple court hearings. You had the earlier method.
I had rescheduled it, and she had told me to, I even came in and rescheduled it.
You did?
Yes, and
all right.
it's hard when,
Let's see what I can recap here. You got arrested on this in July, and they set a pre-exam conference for July 25th.
no.
Yeah.
You guys had arrested me, and I went to court. I was brought into court. We, before I even did the court date, Horshire or with his
See, what had happened is you arrested me. That's just not a good thing to correct the judge with.
name is so hard to pronounce, but he did the intake on that. Whatever fell out when you guys arrested me, and it was all supposed to be put in one because I don't got the money to keep coming in here and paying.
All right, it wasn't all put into one. It's Deputy Wertheimer. All right, so they charge you with a new felony case. You have the other felony case where you had started a payment plan. I'm not sure if you made any payments. So
Yeah,
your
no.
first hearing, stop.
I'm going to guess
Go
no.
through the recap. Your first hearing was July 25th. You posted a bond. You got out of jail, and they told you to be here on July 25th. You didn't show up on July 25th. You called the next day on July 26th, and you said, hey, I missed court. And they told you you had 48 hours to come in and reset it. So you did. You came in on July 27th. And they set a pre-exam conference for August 1st, and you were supposed to contact your lawyer, Mr. Paul Gibson. They gave you the notice and the instructions at the counter. So August 1st comes and you don't show up for that. And Mr. Gibson, I think, said, I never heard from her.
I never.
So we did a bench warrant. And then you called August 2nd and said, hey, I missed my court date. And they said, well, come back into the court. She said she understood. Then you never came back. And then you got arrested on August 27th. So each time you've been a day late and $1 short, which is very common with our methamphetamine defendants, they don't always do a good job of keeping their
Oh, look at her. She takes umbrage with that comment.
appointments. But the other thing you never did is contact your lawyer. So I need to get this case back on track. I'm going to
Well,
reset.
I went from being homeless out in the woods, having no phone, no car, no nothing, to living at my mom's, where my mom took me back in. She has cameras inside of her phone watching me and everything. So
She's come all the way from homeless to sponging off her mother, Judge. Give her a break.
And I never posted bail. I sat my 15 days.
Yes.
And
well, that's because Judge Pattison gave you 15 days. But I'm going to reset the pre-exam conference for next Tuesday, September 25th at 8:30. I'm going to reset the prelim, if needed, for September 12th at 1 o'clock. Mr. Gibson is still your lawyer, although you never contacted him.
Ain't got no money, no phone.
All right, well then we'll make sure that you're there. Bond's going to remain at $5,000 cash or surety. There is some room for confusion here because these cases overlapped.
Can I get someone like that's really like, I know you ain't got time to do this a lot, but can you get someone to like study this case? Because this is not, I don't feel that this is right for me. I feel people are ganging up on me and it's bullshit. I mean, for real.
All right, well, let's talk about this. But there's no excuse for the fact that you didn't show up when you were supposed to. You missed 2 court dates. You called the next day, said, hey, I missed court. Sorry. We're all here, standing here with our hat in our hand, waiting for you to show up.
Well, no, she told me she had already issued the warrant. So I'm like, well, then what?
Well, yeah, so then you didn't come in. So you wait to
she
get
told me to
arrested.
come in and turn myself in. And I'm like, well.
Yeah, okay, so here you are now. So yeah, we're not ganging up on you. We gave you 3 separate opportunities to come in here, and you decided to wait to get arrested rather than come in and turn yourself in. And in which case I would have probably given you a PR bond. So now the bond is $5,000 cash or surety, and we will address this next Tuesday morning with your lawyer, Mr. Gibson.
I will make
and
sure.
I don't think you're going to post the bond, and then he will come see you at the jail.
I was just going to say, I'll make sure that I send a note this morning to Mr. Gibson so he knows she's there and can see her.
All right, very good. You're good to go. She will be better when we see her after 7 days in jail. Anyway, it's never their fault. It's always somebody else's, namely me. Anyway, we will see her at that time. All right, Keith, thanks for your help.
Boy, I'm just getting railroaded here.
Okay. So now we're going on to the Natalie D submission, which I've not seen any. Based upon recent Natalie D submissions, I recommend that nobody watch this.
Oh my goodness, I think I'll get a proper lunch today.
Yes.
Here we are,
Yes.
Ms. Wilson, I need to see your face. Ms. Wilson,
Yes.
I don't need to see your eyeball. Are you driving?
No, I'm actually pulled over on the side of the road. That's what I was doing when you was just calling.
I need to see your whole face, not your cheek.
Okay. Can you see me? Can you see me?
Yeah, why are you looking at the road like you're driving?
No, because I'm actually halfway off. I'm not even all the way.
You are
off.
moving. I see you moving in the background. Let's put it, we're gonna put her in the there you go. All right, so Ms.
Bullshit on that.
Position 20 didn't show up. Is that
It's a dismissal, Your Honor.
That's a dismissal?
We're starting strong.
Are you here this afternoon, Ms. Cruikshank?
I am not, but Mr. Andrew Juski will be.
All right. Ms. Wilson has lost her mind, and she think I'm crazy.
You want me to just give him the results, and you can tell her to come back at 1?
Yep.
All right, I will make a copy, give him the results. It is a pay and stay, and he can announce it at the 1 o'clock calendar.
Thank you very much. Appreciate it.
Thank you, Your Honor. That is my
All
last case. How's that? That's pretty good.
Sure do appreciate you.
You're welcome. Thank you.
Have a great day. Do you like it when I make you the co-host and you can just keep moving?
Yes.
Good. I love it.
So much
I love
easier.
it. I'm trying to make it as efficient as possible. I'm gonna keep trying stuff till I can figure it out.
You know, and I like doing everybody at once and bringing them all back in. Saves me a lot of time. So I appreciate it, Your Honor. Thank you.
All righty. Thank you. Ms. Hart, who is Mr. Ellison and
Mr. Ellison was supposed to be here at 9. He came late and the default has already been entered. It's position 26.
all right, Mr. Ellison, I took this default judgment at 10 a.m. When you were not here. So you were gonna have to contact the attorney, let them know you were here, see if you can work something out with the attorney. You understand that, sir? You're on mute, so I can't hear you.
Hello, you can hear me?
I can hear you now, yeah.
Hey, yeah, this is my first time doing this. I was really trying to figure out because I was following the link, but it was a couple other things I had to do, and I'm really just not. Then when I joined, I was like removed for a little while, and I had to wait till it.
So, Mr. Ellison, let me tell you
to let
something.
me back in.
Let me stop you right there. When we send out these notices, we always recommend that people practice the night before so that you don't run into these issues. Because I have no way of knowing what your issues are. All I know is we start court at 9 o'clock. And in fact, we actually started court at 9:30, but you still weren't here by 10 a.m. I don't know what issues you're having. All I know is you're not here. And so I'm going to ask that you contact the attorney on this case and see if there's something you can work out with the attorney. All right?
Who is the attorney?
Matthew Totten. Ms. Hart, can you give Mr. Ellison the attorney's name and phone number?
Yes, I can.
All right, Mr. Ellison, you can explain to the attorney what was happening and why you were not able to get in, and maybe the attorney will be able to assist you. All right?
So what? I have a call with the attorney?
Tell me what I just said.
You said contact the attorney.
Right. Because I have already entered a judgment against you. I entered the judgment because you were not here.
You already lost, dummy.
All right. Ms. Hart,
Let
will
it
you
sink
give
in.
Mr. Ellison the attorney's phone number? Mr. Ellison, my recommendation is that you call the attorney. Explain to the attorney the issues you were having logging on and see if that attorney will work something out with you.
Like
All
vacating that judgment.
Yeah. Hold on. Where the number just go? It popped up, then it disappeared. Where did it go?
Ms. Hart, will you please send Mr. Ellison the information one more time?
Okay, I got it now.
All right. Any questions before we let you go, sir?
Let me say, I can only talk to him. You said I can't talk to you?
I've already entered a judgment, and so you cannot talk to me without the attorney in the courtroom.
Oh, okay. So like it's no way I can get him in the courtroom or whoever the attorney
You
is.
can ask him to come back. You ask him. See if he'll come back at 1 o'clock.
Okay.
Thank you for calling the Taunton firm. If you
All
know
right.
your extension, you may dial it at any time.
Miss Hart, I'm going to give me a real lunch today. Haven't had a real lunch in a long time on these calendars. We still tell people to practice the night before, right?
And
Okay.
they don't even call here to say anything, but it's like, okay.
All right.
It is.
All
It's
right,
next
go get
level.
yourself a real lunch with your Afro puff.
Aye.
In at 2:13 after I granted the default judgment. So we gave her your number to see if you all can work something out. So
Fancy
Ms.
editing.
Hart, where's Ms. Hobbs?
Natalie
Why we
B.
dragging the attorney back?
She said she was logging back in. She did call because she got notification to be here, and it was wrong. I did get a notification, but it was a slip up on my end.
Got it. All right. So Ms. Attorney Martin, that was our fault, apparently. That's
Okay.
why she wasn't here. So I'm going to send you back into breakout room number 2. And when she gets here, I'm going to send her into breakout room number 2. Okay?
Okay. Thank you, Your Honor.
No, thank you. I appreciate you coming back. Thank you, Ms. Hart. All right, Mr. Dukes, you came back on position number 8. Do y'all have an agreement?
I think we got pulled back on it. We were still talking. Yeah, it
Who
sent us
pulled
both
y'all back
back in.
here?
I don't know. It probably was a mistake by somebody. It's okay. We'll
All right.
go back to the breakout room, Your Honor.
All right, we'll send you back to number 8.
Hello. Is it back on?
We'll send you back to number 8. Please don't interrupt court. Let me see if I can do it, because Ms. Hart, I got her going somewhere. Jesus, I don't know how to. Okay. I'm going to have to wait till she comes back, because I'm getting out of my lane.
She is cute.
Miss Hart. I need Miss Martin to go into number 2. Mr. Duke said you pulled them out of number 8 while they were talking. So I need Mr. Dukes and Miss Jones, T8 Miss Jones. I need them to go back into breakout room number 8.
The breakout rooms were closed by someone, and it pushed everyone out.
It wasn't me. I didn't touch the breakout rooms. All right, I've let Miss Hobbs in. Let's send her into breakout room number 2.
All right.
Hey.
Miss Hobbs, I'm sending you
don't
to
need
room
to just
2.
holler it out in court, ma'am. Let's send Miss Hobbs into breakout room number 2. Miss Jones, let me.
Miss Jones, you can go back into breakout room. I put you in 9.
It didn't give me the little thing to click join. Oh, there it goes. Thank you.
Okay. Okay.
All right, Mr. Wardlaw, any reason you're back? Because you took care of both of your cases. I need you to unmute, Mr. Wardlaw.
Yes, Your Honor, that's what I was trying to announce earlier, was that I think I had a case that was not called on the calendar.
Which one?
Case is ending in make sure, because I don't want to say it wrong. Case is 23 Delta 22077, Belinda Abrams versus Nakia Roberts.
I don't know which calendar you're on, but 22077 was Sadie Reeves. And you just did an agreement with her.
Okay, so it was in this file. Okay, okay, it's gonna be 23 Delta 22732.
22732. I don't think that's on 22, 20, say it again.
23. Sorry, Your Honor. I apologize. 23 Delta 22732.
I don't have that on my calendar today, Ms. Hart.
That's for 9/11 at 9 a.m. at CT2.
Okay.
That is for next Monday.
All right. Thank you, Your Honor. That concludes my business today. My case today. May I be excused?
You may be excused again, Mr. Mr. Wardlaw.
Yes, Your Honor.
All right. Ms. Breedlove. Tell me what we got, Mr. Breedlove.
Oh, here we go again.
Mr. Breedlove, you are mute.
I need to talk briefly to Ms. Caldwell again. I'm trying to move her back to room 3, but room 3 is not showing room 3.
You can always go back. Ms. Caldwell, if you push breakout rooms, you can rejoin that room, and then you can rejoin that room, Mr. Breedlove.
Thank you. Thank you.
All right, Mr. I really don't want to have to put him out, so let's find out from Mr. Ellison why he is back for the 15th time.
Is he driving?
He's driving. Put him back in the waiting room.
All right.
First of all, he's back because he can't pay attention. Put him back in the waiting room. He sent a chat saying, if I've left several messages, if I'm not contacted, what should I do? What do you do when you call your friends and they don't answer?
Right. Just leave a message, and if they get back with you, it's nothing that we can do.
And if they don't get back with you, do you call them again? That's really up to you. I want you to give him some common sense advice so I don't have to.
Okay.
Thank you, ma'am.
Yes.
All right. Ms. Martin, were you able to speak with Ms. Hobbs?
We spoke, Your Honor. I don't know how productive it was.
All right, Ms. Hobbs, hold on, ma'am. Ms. Hobbs, turn on your audio and video. Ms. Hobbs, turn on your audio and video. Ms. Hobbs, turn on your audio and video. Ms. Hart, I need you to get Ms. Hobbs back in court. Otherwise, I'm going to leave the default judgment as it is. You got 2 minutes. You got 2 minutes, Ms. Martin.
Ms. Hobbs, I'm sending you a prompt to start your video. Start your audio and video.
All right, Ms. Hobbs. So gave you and the attorney an opportunity to talk. When you came,
Oh God, she's
when
gone.
you came late,
Hello?
you missed some very. Can you hear me?
Can
you hear me, Ms.
I
Hobbs?
dropped my phone in some water,
Ms.
so
Hobbs,
it's kind of hard.
please. I can't do a whole lot of excuses today. All right. So when you came in late, you missed a.
I don't even know.
I need your complete and undivided attention. All right. When you came in late, you missed some very important information about these types of cases. And so one of the things I explained is that I'm going to give parties an opportunity to try to come to a resolution. But if you can't, we're going to have to set your case down for a trial, and you'll have to pay some rent to the registry of the court. So let me hear from the attorney to see if y'all were able to work anything out. Ms. Martin?
So without delving too much, Your Honor, without delving too much, Your Honor, into the mediation, I was amenable to offering what I was authorized, which was 7 days to vacate. Ms. Hobbs has been somewhat non-responsive and frankly very disrespectful to me. I asked her for an email address so that I could provide a copy of the order, at which point she told me she did not have an email. I asked if she had a trusted family member or friend who could provide an email to receive the order. And she told me she was going to leave the chat because she couldn't text someone, and that was the end.
All right. Ms. Hobbs, what are you asking the court to do? Are you want to have a hearing? Ms. Hobbs, I need you to get back on the video. Do you want to have a hearing?
I'm here. Can you hear me?
I can, but you're not talking. Do you want to have a hearing?
So no, I was trying to go into an agreement, but I was telling her I'm trying to get the email.
Do you have an email address?
No, I don't have one. And I also stated that in the courts when I came to answer.
All right, let me stop you right there, Ms. Hobbs. I'm not here to go head to head. I'm here to see if you all can come to an agreement, because I don't like having to evict people. Is there anywhere or any way that she can get an email to you so y'all can come to an agreement? That's all I need to know.
Yes, but I'm trying to get in contact with my sister. That's what I was telling her. But she's being rude and
Let me
nasty.
stop you all right there. Get in contact with your sister, ma'am, because if you don't, I'm going to have to let this default judgment stand.
Okay, that's what I'm finna do. One moment.
You got 2 minutes. Miss Martin, she got 2 minutes.
Thank you, Your Honor.
All right, Ms. Hart, I hope you're able to speak with Mr. Ellison so I don't have to.
Yes, Judge. Mr. Ellison. Yes.
Yeah, you can hear me?
Yes, I can hear you.
I'm gonna turn on my video. I'm
Okay.
not driving.
All right.
I really, I've been waiting to get my questions answered since like 10 o'clock. And I really had to go to the ATM. Like, I couldn't even wait like this so I can get the money to pay the rent. You get what I'm saying? But I gotta move out the way real quick. But what I was about to say was,
Oh, he's driving.
Okay, you wanted me to contact my attorney. What if I can't get in contact with my attorney? What happens and what should I do then?
You would have to call them back and leave a message.
What if I'm saying if I leave messages, if I can't get in contact with them, then what?
It's nothing that we can do. You would have to contact your attorney because you weren't here on time. You would just have to keep reaching out, sir, okay?
I understand that, but I'm saying, like, what happens if they don't reach out? Like, then what?
Mr. Ellison, you get evicted. That's what happens. All right. So let me make another recommendation. Go to your leasing office. See if you can talk to them, because the problem is you came late. The attorney's already gone. I don't know where that attorney leaves when he leaves here. He may have some other stuff to do, the same way you have other stuff to do and can't seem to talk to us and stay still. So if you aren't able to reach him and make another agreement, you are going to get evicted and you will have a judgment against you. That's it. I can't answer any more questions because the court cannot give you legal advice. I'm trying to give you information on how to prevent from getting evicted, but you came to court late and your opportunity to talk to the attorney is gone. So that's why we gave you the number. Call them, leave a message. When you call your friends and they don't answer, leave a message.
Several.
Do they call?
I
All right,
left
well, then if
several.
they don't call you back, keep calling. I can't tell you what to
They're a fun
do.
group.
All right, Ms. Hart, if Mr. Ellison has any more questions that call for common sense, I think you can handle it.
Anything else, Mr. Ellison?
I'm saying, so wait, you see saying I'm gonna be evicted. If they don't never hit me back and I get evicted, so what? Do I get another notice? Is it, do I get another call? Do I gotta talk to somebody? Because
They don't never hit me back and I get evicted. Okay, Mr. Ellison, at least you finally understand the situation.
constantly try to
So
email.
let me stop you right here. Let me stop
everything with the people who
Ms. Hart,
that I'm renting the place with, and I can't never get in contact.
Let me stop him right here. First of all, he's driving, and we are not going to allow anybody to violate Georgia law by operating a handheld device behind the wheel of a moving vehicle. So if he cannot stop driving, we can't talk to him. Because here's the problem, as I tell when folks are driving, you can't give us your complete and undivided attention. So you're not going to hear the information we're trying to give you because you got to pay attention to driving. Now, I really don't want to have to put him out because once we put him out, he won't be able to come back in. But I need him to pull over and exercise some common sense. Y'all tell me how Ms. Hobbs need to come back here with an email address.
I wouldn't have the patience for this. I'd be like, you're evicted or whatever. You missed the hearing. The order was entered. Good luck. It sure does. Oh, New Zealand. I love it.
I have to step away for a second, Miss Hart. I'll be back.
I wouldn't. She's actually an excellent judge, and she just has more patience than me. If I was on the bench, this is why I'm not. I would say you weren't here. It's over. Whatever the order was, deal with it. Kick him off the stream. Your appearance has passed. If you don't like the result of what occurred, then
Ms. Hobbs, were
find
you
an
able to
attorney
get
and
an
bring a
email?
motion.
Can I get like another minute or two, please?
Another minute or two?
Yes, I'm still trying to get somebody. I'm texting people. That's why I was asking her if I could call and join the meeting back, but I don't know, but I'm still trying on my end.
I'll let the judge know.
Girl.
But I proved that you did.
Barnett, girl, no, don't do that. Just, I'll mute you now, Miss Jones. All right, now, no more girl, Miss Barnett. Now you tell me.
All right, Ms. Martin, tell me, let me get Ms. Martin and Ms. Hobbs back on the video. Ms. Martin, you said you had authority to do what?
So I can provide her with 7 days to vacate the premises.
Okay.
Pursuant to our pleading. I think the issue was that initially I wasn't clear that she wanted to enter into a consent agreement. And then when I was going to prepare the order, she didn't have an email address.
All right.
I'm basically public service.
Well, I've reviewed her answer and it's the equivalent of not having the money. So I'd have to grant you are y'all still not looking for a money judgment? Ms. Martin? No, you don't just interrupt. All right, so Ms. Martin, are y'all still looking for no money judgment?
Correct. It's possession only, Your Honor.
All right, Ms. Hobbs, turn your video on. Ma'am, you can't just come in court, start talking while I'm trying to talk to somebody else. Turn your video on, Ms. Hobbs. Turn your video on, Ms. Hobbs. Attorney Martin, I understand you have a hard stop at 3 p.m. So if you have to check out, go ahead and check out. Ms. Hobbs. Turn on your video, ma'am. Turn on your audio. Turn on your audio, Ms. Hobbs. All right.
Oh yeah.
What were you trying to say while I was talking to the attorney?
Oh, I'm sorry. So I got a question. Well, I know you probably can't answer, but I've been trying to pay my rent ever since August, and they wasn't trying to accept it since August.
What's the question?
So I'm trying to figure out, so if they still not trying to accept it. So for it to not to be on my background, who do I need to pay? Like, in order, like, I'm trying to figure out, like, because I got the money
Ma'am,
to pay it. I'm just trying to figure out who do I need to pay it to
ma'am, I
remove it
don't
off
know.
my
Let me stop.
background so I can find me somewhere else to stay.
Let me stop you right there. I have no idea because I don't know what people do in their leasing offices. But I want to explain this to you. So when you were not here, I explained to tenants how the dispossessory process works. And so when a landlord files an eviction for non-payment of rent, and if your response was that you didn't have the money to pay the rent, that's not a legal defense in Georgia, and I'm required to find in favor of the landlord just based on that response alone. When I reviewed your answer, you said your rent was short because your job shipped your checks off to an old address.
That's correct.
Unfortunately, that's not a legal defense. And so even if we were to have a trial, the best I could do is give you 7 days to move. And so that is what the attorney is willing to offer. That's what Georgia law says I can give you. Now, when they got the default judgment, they weren't asking for outstanding rent. And with the 7 days, they're still not asking for outstanding rent. So the best this court can do is give you the 7 days, and you would owe the landlord no money. Now, if you want to have a trial and tell me all about how they didn't want to take your rent, we can do that, but you will have to pay rent into the registry of the court. And unfortunately, based on your response, you still may not win the case. Do you understand that?
Yes.
All right. Now, I cannot give you any legal advice. So if you ask me for a question about what to do or how to do it, I can't answer that. Did you still have a question for the court?
So I guess I just need to talk to the landlord because you're saying that it's not going to be nothing, like no balance, but the leasing office.
Let me stop you right there. Let me stop you right there. What I am saying is that based on your answer, I have to find in favor of the landlord. And if I were to do that, then the landlord would be entitled to all of the rent that you didn't pay at the rate of, what was it, $1,400 a month? So right now they're asking for you to move in 7 days and you don't have to give them zero. So if you need to talk to whoever you need to talk to. But I think the first person you want to talk to is this attorney here who can enter into an agreement with you. And if she needs an email address, you need to give her that email address because I cannot help either side. And you missed a lot of good information. I'm trying to give you the most relevant information so you can make a good decision. Because sometimes fighting is not a good decision. So, it's 3:00. So Ms. Martin has to go. Ms. Martin, are you willing to talk to her at another time? You want to give her your office number or what? Because at this point, I have no choice but to enter the default judgment. You want to give her your office number, Ms. Martin?
Frankly, Your Honor, I came back in good faith trying to work with Ms. Hobbs, but I don't know how fruitful that would be.
All right, I'm gonna grant the 7 days. Now the question is, Ms. Hobbs, I can grant you 7 days and charge you the July, August, September rent at $1,408 a month, or I can grant you the 7 days with a zero judgment. Either way, you're gonna have a judgment against you.
Okay, so how much I need to pay?
Ms. Martin, you are excused.
Thank you.
I don't know what you need to pay, ma'am. But I can grant this judgment. Let me 1408 times 3. You'd have to pay $4,224 into the registry of the court.
Okay, and when I need to pay that by?
7 days.
Okay.
All right. Okay. So we'll set your case down for a hearing. I will prepare an order requiring you to pay rent to the registry of the court. If you don't pay that rent to the registry, the landlord can ask for a writ of possession and a judgment, a money judgment.
Okay.
All right.
All right. Thank you.
You are free to go. You may hit the leave button that appears on your screen. Ms. Hart, I'm gonna do her craziest thing. Why? Ms. Hart, I need to step away for a second. Hold on for a second.
Okay.
Miss Hart is a saint. She was seriously trying to talk to all those people. She's also a cutie. Oh, am I going to be in trouble now? I done stepped in it. I said that.
That was on me. That's why I had Attorney Martin to come back. I apologize.
No, I appreciate you taking. Look, when you mess up, just take the hit, and that's better than pretending it wasn't you, and then it turns into a whole mess. I appreciate you taking the hit, but getting her back in here, she ain't listening
At
you
all.
get to move and owe no money versus having to move and having a judgment against you. Oh,
right.
I need a moment. I'm so sorry, Mr. Dukes. I need a moment.
I need a moment. She needs to go down to Costa Rica and see if that guy will share his stash with her. That's what she really needs.
All right, Miss Jones, come on back. Ma'am, I typically take a moment when I'm a little full because I don't want to take out my frustrations on you when I'm frustrated with somebody else. So thank you for your patience. Mr. Dukes, were y'all able to come to a resolution with Miss Jones?
We were, Your Honor.
All right, Ms. Jones, I'm going to hear from the attorney what you worked out, and then I'll come back and review the terms with you. Mr. Dukes?
All right, Your Honor. So, Your Honor, similar to the other agreement I did prior today, but a writ of possession will issue on September 15th, 2023 at 11:59 p.m. Plaintiff will voluntarily dismiss, parties, I say plaintiff, but parties, because they have different claims, but specifically the plaintiff will voluntarily dismiss the amount, the judgment and everything. Defendant vacates the property on or before September 15th, 2023 at 11:59 p.m. As well as the
And there'll be no money judgment?
right, Your Honor, the defendant is going to pay on or before September 18th, 2023, $2,264.
All right, let me make sure I understand. I want to repeat it back to you.
I actually know what you're saying.
If the tenant leaves by September 15th, both parties will dismiss their claim and counterclaim? And will money be owed if she leaves on September 15th?
So money will be owed, Your Honor, but the money that's owing is going to be a conditional judgment on, Your Honor, of $2,264.
That is perfect.
She's going to pay it, and that will wrap up
perfect
this whole thing.
All right, so she will leave on September 18th. Both parties will dismiss their claims against each other, and the tenant will pay $2,264 by the 18th.
You know what, Your Honor? Let's give her some more time. Let's say by the 22nd, the end of that
All right,
week.
so that's the payment or the vacate?
That's the payment. That's the payment.
All right. So let me just say it one more time. Ms. Jones has agreed to vacate on September 15th, and if she does that, both parties will dismiss their cases, and she will only owe $2,264 payable on September 22nd.
Right, Your Honor. And then
all right, and if she doesn't vacate by the 15th, then what happens?
sure, Your Honor. That's why I said the writ of possession will issue on September 15th, 2023 at 11:59 p.m.
And will y'all be asking for more money in the form of a judgment?
No, well, Your Honor, I did, well, I will include language that says upon plaintiff submitting a written affidavit of non-compliance, then plaintiff would have a money judgment of $2,264. So
All right, so the number doesn't change.
Number doesn't change, Your Honor. The only thing that I guess would change would be whether or not, all the different conditions were met, because if she didn't vacate, my client would still have to file for a writ of possession anyway.
Right.
So regardless, everything would have to be in writing if there is any type of non-compliance.
All right, so let me ask you this question. One last question before I talk to Ms. Jones. If she leaves on the 15th and she pays on the 22nd, will the landlord dismiss the action?
Correct, Your Honor.
Got it. I got it. Ms. Jones, raise your right hand. Let me put you under oath. Do you swear or affirm you'll tell me the truth, whole truth, nothing but the truth, so help you God, or face the penalty of perjury?
Yes, ma'am.
You may lower your hand. All right. So you had an opportunity to talk to the attorney. And after talking to the attorney, y'all came to an agreement. Is that correct?
Yes, ma'am.
All right. So I'm going to take them one at a time so we don't get confused. Did you agree that you'll vacate the premises no later than September 15th?
Yes, ma'am.
Did you agree that you'll dismiss your claim and the landlord will dismiss their claim under these cases?
Yes, ma'am.
And did you also agree that you will pay the landlord $2,264 no later than September 22nd?
Yes, ma'am. On the condition that I don't have a judgment against me.
All right. I said I'm going to take it one at a time.
Okay.
You
Yes,
get that
ma'am.
part? Okay. All right.
Yes, ma'am.
So if you leave on the 15th and you dismiss your claim and you pay the $2,264 on September 22nd, then the landlord will dismiss all of this.
Yes, ma'am.
And there will be no judgment against you.
Yes, ma'am.
But you have to do all three.
The move by September 15th, pay the amount of 22.
We were so close. And I think
Sweet Jesus. What?
I'm just going to eat a piece of bubble gum to reduce my stress level. See if we can get her back. Ms. Dukes, I think you made it more complicated than it needed to be.
I'm liking Judge Williams more and more.
I know.
She's
We could
just
have
so
made it
damn
real
cute.
easy. Leave, pay, dismiss. That's all we had to do. Leave, pay, dismiss. That's all right. I'm gonna make it uncomplicated. Because you're a lawyer. You can't help yourself. How's your baby boy doing? You're on mute.
Sorry, Your Honor. He's getting big. He's getting really big.
He gonna eat you out of house and home. I can tell you that right now.
I know, Your Honor.
Yep.
I definitely know. So I mean,
Yeah.
I won't be going anywhere. Like I said, you have to worry about me. It's like Attorney Dukes is always here. Attorney Dukes is always here.
He got to be, because he got to work. He got a child now.
Right.
And a son
He got to
on
eat.
top of it.
He got to eat. Just be us staring, just like really say whatever you want. He just sits there and stares. Yeah, it just the judge allows it.
I used to get my nephew every summer. He came one summer and I went to pick him up at his friend's house. And I said, "What would you like for dinner?" He said, "Auntie, I feel like a steak." Well, he about 10. I'm like, "That's funny because you look like a hot dog. Where you work?" A lamb chop. Right. You better get a job.
Right. And the pizza, and you're like, all right. I don't even know where you're putting the food. Like, I'm gonna stop right now. No, Your Honor, I'm lucky. He's a weird kid. I like him though. He likes his berries and stuff, and he loves granola. So that's actually my cheat. It's like here, have a bag
I love it.
of Quaker granola.
I'm gonna say this with all the love and respect I can find. He's weird because his daddy is weird, but you didn't hear that from me. All right. So if we can get her back, she's gonna leave on the 15th. she's going to pay on the 22nd, and then both cases will be dismissed.
Right. All claims are dismissed for
All
everybody.
claims are dismissed, and she will not have a judgment.
Right.
But she got to do all three.
Right. I mean, I can still prepare, Your Honor, but like you said, I don't know where she went. This is weird.
Prepare it. If you got somewhere to go, I'm gonna go over it with her, and if we got to call you back, we'll call you back. How about
Okay.
that?
All right.
She's
All
back.
right.
Oh, she back.
Oh,
All
so I
right.
won't go
All right,
anywhere.
we're gonna have some redemption. We're at the end.
My phone went dead. I'm sorry.
It's all right. It's all right. Let me start over because I figured out a way to try to make this simple.
Okay.
You've agreed to leave on September 15th.
Yes, ma'am.
You've agreed to pay on September 22nd.
Yes, ma'am.
And you've agreed to dismiss your claim, and they'll dismiss their claim, right?
Yes, ma'am.
All right. If you do all three, then there will be no judgment against you.
Yes,
So there will be no judgment to go anywhere. But now, if you miss either one of them, if you don't leave, if you leave late, if you're late with the payment, then that's when the landlord can ask for a judgment against you.
Yes, ma'am.
So you got to do all three, Ms. Jones. You got to do all three.
Understood, Your Honor.
All right. You were repeating it back to me, which made me think you had it figured out. You want to try and repeat it back to me again?
Move by the 15th, pay by the 22nd, dismiss my and don't pursue my counterclaim.
Bam! We got it.
Yes, ma'am.
No, you got it. I appreciate you. Thank you so
Yes,
much.
ma'am.
So
Yes,
here's what
ma'am.
I'm gonna do. I'm gonna ask the attorney to email that to me and copy you on the email. Open it up, make sure it's what you agreed to.
Yes,
If it
ma'am.
says what you've agreed to, you don't have to do anything else. If it says anything different, you have to hurry up and hit reply all within 24 hours. You got it?
Yes, ma'am.
Because I want to sign this. That way you can move on to where you need to be without it having an impact on you.
Yes, ma'am. Thank you.
All right. You are absolutely welcome. Any questions before I let you go?
No, ma'am.
I appreciate your patience. I'm glad you were able to work something out with Attorney Dukes. So
Thank you.
You are free to go. You may hit the leave button that appears on your screen.
All right. Thank you.
You are welcome. Have a great afternoon.
All right. You too.
All right, Mr. Dukes, have a great afternoon.
Thank you. You do the same, and you as well, Madam Clerk.
Thank you, ma'am. Ms. Hart, I don't know why Mr. Ellison is back here, but
Oh, Lord, I need to find it. Where are we here? We need one. We need one in the worst way. Yes, that's right.
Oh my gosh, it is a double rainbow. I cannot believe it. It's a freaking double rainbow.
Oh, good Lord. We got through that, but we had redemption. We ended with a successful hearing. We ended with it. It actually got better after all that. That was really fun. Thanks again to Natalie D. That was fun, and it was absolutely horrible. It was excruciating, but it was horrible and excruciating in a way I wasn't expecting. There were no thruples. There were no felonies. Just weapons grade stupid through and through, and technical problems. But in the end, we got that. Now, the last one I have the most hope for, but still, she's got to move and pay. Those are affirmative actions. The odds of her going 2 for 2 on that are, I don't know if they're good. All right. Thank you all for coming out. I appreciate it. I will see you all soon.